Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we have a situation where we have an accident in one state and a lawsuit in another. And we have to decide what state's law applies. I'll explain more in just a moment. So Mary lives in Missouri, and her friend Shirley lives in Kansas. And Mary gets in her car and drives over to Kansas to pick up Shirley because they have a lunch date. And while they are at their lunch date, Shirley claims that Mary had 6 beers, and Mary says she barely finished one, and that she was not impaired when the truck hit them. Now, Shirley's very badly injured, and she decides that since Mary is not, her insurance company is not paying up, that it's time to sue. But instead of suing in Kansas, where the accident happened and where the law limits her recovery in certain respects, Shirley goes across the state line and sues in Missouri. So what state's law will actually apply? Well, to get to this, we have to look at the history involved, because up until the late 1960s, there was a fairly hard and fast rule in most states called lex loci delicti. Lex loci delicti is Latin for the law where the accident occurred, essentially. The jurisdiction, which is the place where the accident occurred, is the tort law that applies in that situation. So that was sort of the universal approach up until the 1960s, when there was sort of a reformation in the laws, and one of the things that happened was that there was a restatement of the law published. Now, the restatement is a book that is put together by law professors and judges and experienced attorneys, and it looks at issues in the law and it tries to formulate law or rules that will be applicable across the country. Doesn't always get the job done, but it tries really hard. The restatement had just come out in 1969 when an interesting case arose in Missouri involving 2 Missouri citizens who were involved in an accident in Indiana. And Indiana had a guest statute at the time that limited the recovery. So the question for the 2 people who sued in Missouri was whether Indiana's guest statute would apply in this particular case. And at the time, Missouri's Supreme Court recognized the lex loci delicti rule. So what happened? Well, here is what the court said in Kennedy versus Dixon. We have concluded that we should abandon the inflexible lex loci delicti rule in favor of the rule set forth in Section 145 of the proposed official draft of Restatement Second of Conflicts of Laws. Applying that test to the facts of this case, it is clear that Missouri has the most significant relationship to the occurrence and the parties. Of course, the injuries occurred in Indiana, and that is the place where the negligent conduct occurred, but as some of the writers in the cases have pointed out, we do not engage in the mere counting of the number of contacts, but must evaluate them in order to determine what state has the most significant contacts. So, we're looking at something called the most significant contacts. In other words, what state will be most affected by the decisions that are reached in this case? So the Missouri Supreme Court went on to state, Indiana's only real interest is in requiring that Missouri residents comply with its standards of care for operation of the motor vehicles on its highways. No interest of that state would be served by applying its guest law for the purpose of determining the host-guest relationship between these Missouri parties. On the other hand, Missouri has a real interest therein. The parties are residents of Missouri, made arrangements for the trip in Missouri, and traveled in a car licensed and garaged in Missouri. The whole relationship of the parties is centered in Missouri. As a result, the court abandoned this lex loci delicti rule in favor of the most significant relationship test. And since then, courts have repeatedly applied this test, as is shown in this case. All parties recognize and acknowledge that when determining choice of law issues relating to a tort action generally, Missouri courts apply the most significant relationship test as set out in Section 145 of the restatement. By its terms, Section 145 is framed upon and is viewed in light of Section 6 of the restatement second of conflicts of laws. The basic principles governing choice of laws are those enumerated in Section 6. Section 145 simply provides that certain contexts can be taken into account in determining the choice of law under the principles of Section 6. So what are some of those principles? Well, the residency of the parties, the location where the accident occurred, the interests of the forum state, for example, in Mary and Shirley's case, the interests of Missouri, and the interests of the non-forum state, or the state where the accident occurred. So the court has to balance all of these interests and decide what state's law applies. But wait, there's more. And that's because this is an issue-by-issue determination. Now, you're probably thinking, well, what does that mean? Well, it means that the liability rules may wind up being different than the damages rules. For example, in the case where Shirley comes across the state line to sue in Missouri, she is suing in Missouri. That is her choice of forum, and Missouri courts routinely respect that choice of forum. But they have to apply the law where the accident occurred with respect to liability, because that's the state that has the most significant relationship. The state of Kansas would have the most significant relationship in applying the law of Kansas to motor vehicle operation. So that's whose law is going to apply there. But what about damages? Shirley wants her pound of flesh. She wants that money for, her friend having had a little bit too much to drink and not seeing that gigantic big red Mack truck smack her in the middle. So whose law applies? Well, on damages, again, the issue is you have a Missouri resident who is entitled to the protection of Missouri law, and you have a Kansas resident who is seeking the application of Missouri law with respect to damages. And in many cases, again, depending on the other factors involved in the case, including whatever arguments are made by counsel, the law of damages may very well apply in Missouri, where Shirley can get punitive damages, as opposed to the law of Kansas, where instead of being determined by a jury, punitive damages are determined by a judge, and judges tend to be a little more stingy on punitive damages than do, for example, jurors in the cities of Kansas City and St. Louis, who are known to be quite generous with respect to their punitive damage verdicts. So that is how conflicts of laws works with respect to the tort actions in Missouri. Now, generally, again, this is a general rule, generally contracts are determined by the choice of law provision in the contract. And we'll talk about that in a separate video in a couple of days. But not every issue is satisfied by this most significant relationship test, because when the legislature has spoken, well, then the legislature's decision controls on choice of law. For example, the law with regard to banking and instruments that are written, checks, and that sort of thing. There's a Missouri statute right on point, and here's what it says. The following rules apply unless affected parties otherwise agree, or subsection C applies. The rights and obligations between the sender of a payment order and a receiving bank are governed by the law of the jurisdiction in which the receiving bank is located. So that's a little treatise this morning on choice of law rules and choice of forum and that sort of thing. I hope you found that interesting. I would point out one thing, and that is that this is one of the areas where having the most skillful lawyer is probably to your benefit. You need someone who understands public policy, who understands these choice of law rules, who understands how to get a court to apply the choice of law that is most favorable to you and deny the application of the law that is most favorable to the other side. Usually this is an indication, it goes almost entirely on the rhetorical skills of the lawyer and the precedent that's been decided. So if you have somebody who is very good at distinguishing other cases and at arguing in front of courts this is the place where you want them to be, because this is a very important area and will often determine whether an insurance company will settle or whether they will fight to the bitter end on some of these questions. If you have any questions on this, please leave them in the comments down below. Otherwise, all the stuff we ask you to do every time, like, share, subscribe, all that stuff. I appreciate you watching. I hope you had a wonderful holiday, and we'll see you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.